Good afternoon to all of the participants. Hope you had a lovely lunch break. For our second online class, we will have a special presentation by Dr. I Dewagede Palguna, SIM Hum, a former judge of the Constitutional Court of Indonesia. And the topic brought this afternoon is regarding the Constitutional Court and the protection of constitutional rights in the 21st century. The session will be moderated by Mr. Diasta Manggita Ramadan, SH LLM. So before we begin, please allow me to read the CV and introduce our moderator. Our moderator is Mr. Diasta Manggita Ramadan. He received his bachelor's degree from Universitas 11 Maret Surakarta and master's degree in human rights law at Cardiff University, United Kingdom. Currently, Mr. Diaz is a lecturer here at the Faculty of Law, teaching constitutional law. Mr. Diaz, the platform is yours.
Thank you, Daniel. Good afternoon, everyone. Good afternoon, participants. Good afternoon, Bapak Palguna. And before we start the discussion, let me read Dr. Palguna CV or biography. Today's speaker, his full name is I Dewagede Palguna, Dr. I Dewagede Palguna SIM Hum. He was graduated from his bachelor degree, he was graduated from Universitas Udayana, Faculty of Law, majoring in constitutional law in 1987, and then he continued his Master of Law degree, and he was graduated in 1994 from the Pajajaran University, and then he continued his doctoral degree. He was graduated in 2011, and quite an astonishing job experience. He is also a lecturer at Universitas Udayana, head of International Law Department at Universitas Udayana Bali, and then he is also former of judge in Indonesia constitutional law. Without any further ado, Dr. Palguna, the screen is yours.
All right, thank you very much, Mas Dias, for your introduction. And I would like to thank for the organizing committee for giving me a chance to share my experience and maybe some knowledge about the recent development in constitutional law, especially concerning the activities of the Constitutional Court, where I've been served for more than 5 years. And maybe what I would like to say in this wonderful occasion should be valuable to all the participants of this academic forum. Okay, I would like to share the topic about the 21st century Indonesia, the Constitutional Court and the protection of human rights. It has been 23 years now when an historic pro-democracy movement called Gerakan Reformasi in Bahasa Indonesia, or Reform Movement in English, took place in Indonesia. The movement, pioneered by students, right activists, and other prominent pro-democracy figures, had fundamentally changed the country's political landscape forever. And it successfully ousted the then President Suharto from power, which had been in his hand for more than 2 decades, in a dramatic way. And the fall of the president, who once dubbed the most powerful leader in Southeast Asia, had also ended his iconic New Order regime, and at the same time opened the door of the country's democracy. Among the movement's most fundamental demands was the amendment of the country's constitution, which is famously called the Constitution of 1945. And the establishment of the Constitutional Court, hereinafter referred to as the court, was an inherent part of this process. And now the court had been given a pivotal role within the reinvented, quote unquote, reinvented constitutional democratic state of Indonesia, pursuant to the, again, quote unquote, newly amended Constitution of 1945, hereinafter referred to as the Constitution, which now strongly upholds supremacy of the Constitution principles. It was called reinvented. Why I call it reinvented? Because the pursuit for a constitutional democratic state, Indonesia, had actually been clearly stipulated in the preamble of the Constitution in paragraph 4, but we all know it had never been appropriately elaborated in the articles of the Constitution prior to the amendment. Even to some extent, those articles of the Constitution contradictory to the spirit of the preambles. Now, all right, we are now, let's start with the principle of constitution, with the condition which is called the constitutionalism, which is the first and foremost conditions of a constitutional democratic state. One of the most important substances of the constitutionalism is the idea that constitution is supreme in a particular country because it is a fundamental law to the country. We all know where this idea came from. The famous decision of the United States Supreme Court during the Marshall Court, the Marbury versus Madison. This is where the guardian of the Constitution nickname derived from. This idea, I mean, the idea that the Constitution is supreme, must be applied and actually upheld in the state practices. This is from which the principle of the supremacy of the Constitution derived. And the adoption of the court is to ensure this principle, the principle of supremacy of the Constitution, works. In other words, the existence of the court is to safeguard the Constitution so as to make it to be observed and upheld in reality in states' daily practices. That's the reason the court is given a nickname, the guardian of the Constitution. Now, according to article, let's now we go to a further elaboration of the Constitutional Court of Indonesia, or the hereinafter we call it as the court. According to Article 24C, paragraph 1 and 2, the Constitution, the court, whose decisions are final, has the jurisdictions at the first as well as the last instances to review firstly, to review the constitutionality of laws. Secondly, to decide disputes of authorities among state organs whose authorities are given by the Constitution. Thirdly, to decide the dissolution of political parties. Fourthly, to decide the dispute on the result of general elections. Why we call it general elections in plural terms? Because there are many general elections in Indonesia. Firstly, of course, the general election to choose president and vice president, and general election to choose the member of House of Representatives, member of regional representative council. So there are many general elections here in Indonesia, which all the dispute of the result of these general elections shall be in the hand of the Constitutional Court. The fifthly, is to give decision on the opinion of the House who considers that the president and or the vice president had done some violation stipulated in the Constitution. Maybe this is quite similar to the process of impeachment in other constitutional system, like in the US, for instance. Now, for the time being, the court temporarily is also given the jurisdiction to settle disputes on the result of regional elections, which is election for governor, election for region, election for mayor. It is now temporarily is in the hand of the Constitutional Court to decide the result of the dispute of the result of these regional elections. All the above mentioned description on the jurisdiction of the court, whether directly or indirectly, relates to the protection of constitutional rights, which is a kind of condition sine qua non for any constitutional democratic state. Either such rights belong to individual or to legal persons, including state institutions. Just to mention some instances. Now, in the 21st century Indonesia, any law which either its enactment process or its substance is considered unconstitutional can be reviewed before the court. And this will be elaborated further. Another example. Now, the government, in this case the president, can no longer arbitrarily dissolve political parties which are considered opposing to the government, or because they hold different political beliefs, as happened in the past. People can now freely form a political party based on her or his political belief. Now, a political party can only be dissolved if it's proven that its ideology and or its purposes, its programs, its activities are against or contradictory to the Constitution, and it must be decided by the court. Another example. Now the People Consultative Assembly, or the MPR, Majelis Permusyawaratan Rakyat in Bahasa Indonesia, can no longer ousted a president solely based on the Assembly's own political considerations, as happened in the past. For now, the president is directly elected by the people through popular vote mechanism, instead of selected by the Assembly as practiced in the past prior to the amendment. And now, not less important, and now every single vote casted during the general elections, either to put president or vice president, or for members of the National and Regional House of Representatives, or for members of regional representative councils, counts. Contrary to the past practice, during the heyday of New Order regime, where no legal remedy to settle disputes on the result of general elections, now such dispute can be brought before the court for settlement. Okay, let's now we talk more about protection of the constitutional rights. Now, every single citizen of the Republic who considers that his or her constitutional rights infringed by a law is given a standing to file a petition for judicial review on the constitutionality of the law before the court and ask the court to declare the law unconstitutional. A petition for judicial review of a law may be directed at either the constitutionality of its process of enactment or of its substance, whether its articles, its paragraphs, or parts of the law. And if a petition is directed to the constitutionality of the law's enactment process, such a petition is called in Bahasa Indonesia pengujian formal or formal judicial review. While if the petition is directed to the law substances, whether to its articles or its paragraphs of an article or part of the law, any part of the law, this petition is called material judicial review. To file a petition for judicial review, a citizen doesn't even have to be represented by a lawyer. This is a matter of principle. But lately, for technical reasons, a petition without the presence of a lawyer was now very rare. If a petition is written or founded, the court then will declare that the law is unconstitutional and is no longer has its legally binding power, either wholly or partly, which depends on whether the founded petition is formal or a material judicial review. If a formal judicial review petition is granted, meaning that the petition is recent or founded, the court will declare the whole law is unconstitutional and no longer has its legally binding power. While if the case, in the case of a material judicial review petition, if it is granted, the court will declare only the substance of the law concerned, which is considered unconstitutional and is no longer has its legally binding power. The whole process is free of charge, except if the parties concerned, whether the petitioner, the lawmaker, or the president, want to submit witness or expert to be heard before the court. They must pay for them on their own expense. But there were occasions in which the court itself considered that it needed to hear some particular witnesses or experts. In such cases, the financial burden was laid on the court. It might be summarized then now that in the 21st century Indonesia, a single citizen of the Republic, if a single citizen of the Republic of Indonesia, every single citizen of the Republic of Indonesia is constitutionally given a right to challenge a law which, according to our constitution, is a joint product of two democratically elected state organs, in Kasu, the House of Representatives and the President, and to some extent, to some particular issues, especially related to regional autonomy, even plus the role of the Regional Representative Council or Dewan Perwakilan Daerah in Bahasa Indonesia. Well, now let's we talk about the court's digitalization. Guided by a vision to become a modern and most trusted judiciary, the court, since the very beginning of its existence, had adopted and continuously updating technologies considered relevant to optimize its performance, especially in the field of information and communication. This is a significant effort to maximize access to justice for those concerned, especially justice seekers or the justitiabelen. The court had created and developed a judicial system based on information and communication technology, or the ICT, called the e-judiciary. It had been used to provide extensive and convenient access to justice seekers across the country. This includes electronic filing, video conference, court recording system, case retrieval system, and live streaming. Now, let's talk about what is the electronic filing. Now, with the operation of online application system, applicants or petitioners don't need to come physically to the court building to submit their application or petition. The system is very helpful, not only in terms of broadening access to justice, but especially in terms of efficiency. However, there are three main challenges here. Firstly, with such a vast territory of the archipelago, not all regions in the country have sufficient and equal internet access. Secondly, not all people, especially justice seekers, understand the online application technology, let alone of being accustomed with it. Thirdly, the biggest one is to change habit, to move on from conventional mechanisms, that is carrying physical application files and evidences, to paperless mechanism provided by this online system. This is three main challenges with electronic filing. E-case registration. Should an application submitted to the court meets the needed requirements, it will be directly recorded and electronically registered in the e-case registration system. This system significantly helps the court staffs in arranging and scheduling effective hearings, as well as ensuring that case management processes are handled quickly and optimally. Those benefits are possible because, unlike the old or conventional system in which calculation and arrangements of hearing must be done manually, the new system can help to record a case, identify a suitable slot of hearing, and find out how long will it take for a case to be examined and heard. The parties concerned and the general public can see the progress of a case by visiting the court website, www.mahkamahkonstitusi.go.id. It means that the court website, at the very least, eliminates the need of parties to contact the court staff only to find out hearing schedules and or the progress of a particular case. And in addition, the court had decided that documents submitted by the parties will become public documents. It means that the general public is given an access to read documents through the court website, so they will be better understand the cases being examined by the court, especially those which attract public attention. Video conference hearings. The process of the court hearings can also be carried out by using video conference facilities. For years, the Constitutional Court has developed cooperation with 42 universities in 34 provinces throughout the country to place its video conference facilities and devices, which are owned by the court, but the daily maintenance of them is carried out by local staffs assigned by the university where the facilities are installed. With these facilities, all Indonesian regions are connected to the court, which is located in the capital of the Republic. Thus, the parties to a case, especially petitioners, can simply go to the nearest university to conduct hearings. It means that now distance is no longer an obstacle, costly and time-consuming, since, for example, if they have a witness or experts to be heard before the court, they no longer need to fly to Jakarta. And with these video conference facilities, the court can hear testimonies and or expert opinions, not only within the scope of the country's territory, but also from other countries, from other continents around the globe. In the meantime, when these facilities are not being used by the court, they can be utilized to fulfill academic purposes, such as to organize public lectures with universities within Indonesia and abroad, which can reach a large number of participants. I think this is another contribution of the court to the field of academic. Case tracking system. With a view to make information more transparent, the court implemented a policy to upload every application file along with other relevant documents from the parties into the court website. With this policy, anyone, especially the parties to a case, can search the ongoing case to find out the next court hearing schedule or when the decision of the case will be heard, will be read. Video streaming. The use of ICT is also implemented through video streaming facility available on the court website by broadcasting the whole hearing process live. This facility enables the general public to follow the court hearings without having to attend the courtroom, especially quote-unquote high-profile cases. Now, the court had expanded the access to video streaming by connecting it to the court YouTube channel, which has been subscribed by more than according to the latest data, more than 30,000 subscribers, around 34,000 and so. Quite a significant numbers for non-entertainment channel. Our court recording system. One of the significant strengths of the use of ICT by the court is the availability of transcripts and minutes of each hearings that can be carried out quickly and precisely. Record from every hearing process are recorded in an audio and visual formats, which are then converted into a transcript of a written document. A standard operating procedure, SOP, standard operating procedure applied by the court says that transcripts and audio recording must be uploaded into the court website no later than 6 hours after a hearing is completed. This SOP must be applied regardless of whether the hearing was a lengthy and tiring process or not. Okay, that's it. Our presentation and the other features you can see maybe later. Thank you. Terima kasih. And I'll give back the chance to the moderator. Thank you very much, Mas Dias.
Okay, thank you, Professor Palguna, for the wonderful presentation. And now I will start the discussion. And every participant, you can ask your question directly to Dr. Palguna, or you can type your question at the chat box. Okay, and then you can I will read it for you, the question. Okay, it seems like we've had our very first question, Pak Palguna.
Yeah.
Yeah. From Nick, Queen Mary University. Good day, Professor. I've had several questions regarding this topic. Oh, this is the first question, his first question. The first one, do you think that the online court system, especially during this pandemic, can change the whole court system? Not only constitutional court in Indonesia, but it might also all court in all around the world. That is his question. I mean, like his first question.
Yes. Thank you, Mas Dias, and thank you, Nick,
Nick.
for the question. Yes, I think absolutely yes, because we have to choose whether we have to fulfill our obligation to hear a case, or just to let it be delayed. I think it's not a wise choice to make a delay of a case, because we know all that justice delayed is justice denied. Yeah. Yes, I'm absolutely positive about what your question. That's I think not only in the Constitutional Court, but also all the court during the pandemic maybe followed the suit with what happened with our Constitutional Court, with the course of our Constitutional Court. Even I just lately this morning, I presented a kind of this issue within the Commission of Information, the Republic of Indonesia Commission of Information, that who is also a quasi judicial process to give access for the general public for right to know. Yes, also applying the same principle, hearing a case. Okay, thank you.
Okay, thank you for the answer, Pak Palguna. And then the second question is from Shaswan from UKM. His question, he had two questions. His question, greetings, Dr. Palguna. My name is Shaswan from UKM, Malaysia. I have several questions. First one, in Malaysian Federal Constitution, it is provided a clause about proclamation of emergency. Is the Indonesian Constitution also has the provision about proclamation of emergency, and does this provision has the sunset clause? And then the second question from Saswan, is there any example of event in Indonesia history that proclamation of emergency has been used? I mean,
okay,
like
thank you.
Regarding the pandemic, maybe this whole situation.
Yes, of course. It's we can refer to the what is this, maybe article yeah sorry, this is article 12, keadaan bahaya, the state of danger, and the case of emergency. Of course, yes, we have a clear clause or article in our constitution calling the state of emergency, and even now we have a law on the state of emergency, whether because it is because of, and now we are applying the what is Indonesian the clause of proclamation of emergency according to our undang-undang or law on state of emergency. Yes, I think we have it. Thank you.
Okay, thank you, Pak Palguna, for the answer. And then, here comes the second question from Nick. Does constitutional court system will only suitable within a country who used presidential system? Moreover, since there are two types of constitution, written and unwritten, is there an example of a country who used unwritten constitution who had constitutional court?
Okay, this is an interesting, quite challenging question, because yes, as far as I know, it is not depend whether country is a presidential system, use presidential system or parliamentary system. Let's, for instance, even the first constitutional court, it is applied in a parliamentary system. It was in Austria, and now the very leading constitutional court is in Germany, which is also a parliamentary system. So it it doesn't matter whether the system of a country is presidential or parliamentary. It has nothing to do with whether it will adopt the constitutional court or not. And as to written and unwritten constitution, if I'm not mistaken, which is now maybe there are only 3 countries that applied or that who had applied or who has unwritten constitution. It is British, yeah, the Great Britain and New Zealand, if I'm not mistaken, and Israel, I think. And if we refer to these countries, yeah, they have no constitutional court. But I don't know. But I think, yes, maybe if we refer to the principle that in these countries who applied unwritten constitution, this country also use or applied the parliamentary system or the principle of what is the supremacy of the parliament. In such countries, there's a principle that there is no difference between ordinary law and constitution because it depends on the parliament whether to change the rule of the constitution or not. So I think it is not suitable with the principle of supremacy of constitution, which is the main principle to be used when one country adopted constitutional court. Thank you.
Okay, thank you, Dr. Palguna, for the wonderful answer. And then we move to another question from Danish. He's from UKM, University Kebangsaan Malaysia. Greetings, Dr. Palguna. I am Danish from UKM. I want to ask how court deal with connectivity and loss of signal during video conferencing, hearing, especially when witnesses are testifying. I also want to ask what will become main issue for other countries to adopt Indonesian court model in adopting the said technology. This is technical matters, Dr. Palguna.
Okay, of course. Frankly speaking, I have no answer for the first question. What will we do? But I think there will be, if that quote unquote disaster is really happen, I think the parties concerned will be given a chance maybe to for another hearing. That's what I think about. And the second one, I also want to ask what will become main issue
for other countries,
for other countries to adopt Indonesian court model. Of course, the main issue will be that if one country want to adopt the constitutional the model of which is now adopted in Indonesia, maybe the main issue, of course, in terms of the fundamental issues, that the country who would like to adopt this kind of system must apply the principle of supremacy of the constitution. That's the first condition, I think, the first and foremost condition. And secondly, of course, they would if they would like to adopt the technology, I think there's no kind of preconditions whatsoever, but because it is, I think, just a technology as usual. Because now, as far as Indonesia is concerned, this kind of ICT, information and communication technology, had also have been adopted by the courts within the scope of or under the supervision of the Supreme Court of the Republic of Indonesia and other court, whether it is quasi court or a real court in Indonesia. Thank you.
Thank you, Dr. Palguna, for the answer. And then next question from Shahira from Taylor University. She is appreciating the use of technology within the Indonesian court. So her question is, does Indonesian court recognize the use of digital or electronic signature? Can it be used to enforce legal documents?
Yes. Now we, actually, we already have an internal regulation about this, the use of this digital signature, especially for correspondence issues. To this, but again, as I said in my presentation, not all parties, especially justice seekers, that already well accustomed with the newly adopted technologies. That's our big challenge when we are talking about the use of digitalization in the court system. Is there anything left?
Okay, next question, Dr. Palguna.
Okay.
Again from Nick, Queen Mary University. Does constitutional court in Indonesia is similar as human rights court in European court?
To some extent, maybe yes. In terms that, in terms of who has the standing to file petition before the court, especially when such persons or a party consider that his or her constitutional rights are impaired or infringed by an enacted law. If that was the case, I think the Constitutional Court is quite similar to the what is the Human Rights Court, and also in the process, the what is called the rational decidendi of the Constitutional Court decisions, also considering whether the law concerned is being reviewed by the court is violated constitutional rights, or you know, constitutional right is sometimes derived from human rights and introduced into a constitution, so it is called constitutional right. It can be defended before the court, and so it means that if one constitutional rights, it's also a human rights and can be defended before the court, and also become one reason to consider a law unconstitutional if it is proved if it is proven violated some constitutional or human rights. Okay, that's my answer. Thank you.
Okay, thank you, Dr. Palguna, for the answer. And then next question, again from Saswan. My next question is, may I know how the Constitutional Court judges interpret the Constitution when there is ambiguous terms in the Constitution that need to be decided in the court? Is there any principles that need to be adhered by the court in order to interpret the Constitution?
This is an interesting question. Thank you very much. Of course, yeah, there's some cases of the kind. If if this is if there is a case like that, we of course we have to follow what is called the canon of interpretation. The canon of interpretation. If there is the rule was so vague, of course at least we must follow three kind of canons of interpretation. Firstly, what is called the principle of the unity of the Constitution. Secondly, what is called the practical coherence, the principle of practical coherence. And thirdly, is the appropriate workings of the rule of the constitutions. Together, this will be the most fundamental consideration of the court to decide what the rule of the constitution is, the purpose, the meaning of the rule of the constitution, and the purpose of the rules or the norm of constitutions. Thank you.
Okay, thank you, Dr. Palguna, for the answer. And then next question is from Andi Chandra. Good afternoon, Dr. Palguna. I have a question. So as you mentioned before, about a single citizen of Indonesia is constitutionally given a right to challenge a law. So my question is, what condition that a single citizen can offer into the Constitutional Court? I mean, because as far as I know, Constitutional Court is about like something related with regulation, political parties, general election, etc. Thank you, Dr. Palguna.
Okay, there is an example. A person named Pak Fatul Hadi from a remote area in Banyuwangi, the village of Banyuwangi in the eastern part of Java, in the eastern Java. He came to the court, filed a petition concerning the law on budgets, on state budgets, claiming that the law is unconstitutional because it violates the principles of must 20 that the budget for education must not less than 20%. He came to the court even without a lawyer, and then the court granted the petition and declared that the part of law on state budgets concerning the fund for education is unconstitutional and must be fulfilled by the government. So if the question is how someone will be will have a chance to challenge such a law, it depends on whether you have the right or the reason or that your constitutional right or your constitutional rights considered is considered infringed by a particular law, then you have the right to challenge such law, even without a lawyer. Thank you.
Okay, thank you, Dr. Palguna. Again, we've had several questions more. Does the Indonesian Constitutional Court can dispute the international law matter?
Constitutionally, no. But in some of the Constitutional Court decision, international law is also given a chance to be one aspect to be considered by the Constitutional Court in a particular case. For instance, when we are talking about the development of human rights. But if the question is if the question means that whether a law in Indonesia can be challenged or can be challenged because it considered against international law. No, the court has no such jurisdiction or such competence. Thank you.
Okay, thank you, Dr. Palguna. We move to next question. Is there any amendment has been made before in the Indonesian Constitution? And what is your opinion on the amendment of Constitution? Whether it could jeopardize the spirit of Constitution itself?
Okay, this is quite a challenging question. Is there any amendment has been made before Indonesian Constitution? Not before 1999. And whether, what is in your opinion on the amendment of the Constitution, whether it could jeopardize the spirit of the Constitution? Oh, I think it's not. As far as the amendment of the Indonesian Constitution, it was done on to uphold the very spirit of the Constitution that is stipulated in the preamble of the Constitution of 1945. You know, the preamble of the Constitution, what is Hans Kelsen called, is what is called the solemn introductions of the particular state principles, whether in politics and law and so on. So it is very important to identify the spirit of the Constitution says in the preamble of a particular constitution. Thank you.
Okay, thank you, Dr. Palguna. And then we move to the next question from Shara. I have another question to ask Professor Palguna. When the constitutional law is in conflict with international law in Indonesia, which one will prevail?
This is a kind of tricky question. Thank you. As far as you know, as far as if I'm not mistaken, that Indonesia, in terms of the doctrine on the relation of national law and international law applied in Indonesia, Indonesia is belongs to the dualism doctrine. So we are not monism. It means that international law is if it want to be applied in the scope of in the territory of the Indonesia, it must be implemented into a national law first. That's what our interpretation of Article 11 of our Constitution that contain the authority of president to make international agreement or international treaty that must be fulfilled the conditions given by our Constitution, the Constitution of 1945. So, if the question, I notice not black and white here in this case, because the preamble of our Constitution says that Indonesia should participate in international relations, international. So it means that when some international law to be adopted as national law, the national law of Indonesia, there may be a presumption that the adopted international law has been not in conflict with our constitutional law, but in an extreme case where international law is it's in conflict with our national law, of course the international law will prevail. Thank you.
Okay, thank you, Dr. Palguna. We move to another question from Danish. When government try to ratify international treaty or international law and citizens of Indonesia feel it's violated their rights, can it be brought up to constitutional court, and can court stop the government action?
Constitutionally speaking, there's no clear answer for this question. But as far as I understood, the principles of protection of constitutional rights, of course, every Indonesian citizen has the right to um, to uh, to give their voice heard, especially during the process. Of course, during the process of the treaty making, especially you know when in there are many steps of treaty making. Maybe what is the negotiation? Maybe during the negotiation, uh, the voice that of the Indonesian citizen, if they consider that their rights is violated, it can be heard before the House, who had the authority whether it would ratify the treaty or not. It is in the hand of the House of Representatives to give their final say. And can it be brought to the Constitutional Court? Of course, if it considered violated the Constitution, it can be brought before the court. But up to this very day, I think maybe there are one or two cases concerning the issue, but the court did not grant it the petition. And can court stop the government action? No, the court does not have the right to stop the government action, because it is clearly said in the Constitution that the power or the competence to make agreement or international treaty is in the hand of the president with the agreement of the House. Maybe if if in the future that such law derived from an international agreement or international treaty is considered against the Constitution, of course, every citizen of Indonesia have the right to challenge that law. Thank you.
Okay, thank you, Dr. Palguna, for the answer. So, fellow participants, we still have quite much time. Is there any more question do you want to ask to Dr. Palguna? Of course, you can ask it directly using raise hand feature. Okay, seems there is no question, Dr. Palguna. So since there is no more question, Dr. Palguna, you can give your closing remarks or your closing statement.
Okay, thank you, Mas Dias. I would like to thank again the organizing committee, the fact, especially in the case this case, the Faculty of Law of Diponegoro University for inviting me to have a chance to share my experience really in the field of constitutional law to be shared by the participants of this wonderful online summer law. Thank you very much, and see you again in the next occasion. Thank you.
Thank you, Dr. Palguna, for the wonderful speech and wonderful question and answer session. Thank you, every participant who joined the discussion for this afternoon. And I would like to say thank you for all of you who already joined this summer course session. Thank you, Dr. Palguna, and I will give the time back to you, Daniel. Thank you, Dr. Palguna.
Thank you.
Thank you, Dr. Palguna and Mr. Diaz, for the presentation and the discussion regarding the Constitutional Court here in Indonesia. Dear participants, before we end the session, we would like to have one photo session before we end. So please turn on your cameras and take position. Is there any more? Okay, let's take the picture. Ready? 1, 2, 3. One more. 1, 2, 3.
Okay.
Thank you, participants.
Thank you. Bye.
Thank you and have a lovely afternoon. See you tomorrow.
Thank you, Dr. Palguna. Thank you. Thank you, everyone.
Welcome. Thank you very much.